Okay, welcome everyone to this very special session with Support for Families. We have Joanna Van Brusselen, who is here with us and is going to offer the IEP clinic that they host for families and community members. And so with that, I'm going to pass it on to you, Joanna, and thank you everyone who's here for your energy. At the end of our time, I'll stop recording and folks can ask questions.
Wonderful. Thanks, Jerica, for having me. I'm going to share my screen and then we can begin. Okay, slideshow. Okay, can you see my presentation?
Yes.
Okay, great. Hi, everyone. My name is Joanna Van Brusselen, as Jerica said, and I'm the Education Manager at Support for Families of Children with Disabilities. We are a family resource center and a parent training institute that is located in San Francisco, California. Today, we're going to speak about the Individualized Education Program, or IEP. We're located in Soma District, and we're actually about to move to 4th and Folsom, so we'll be moving in the next couple of weeks. Over there, and this information will change, but most likely we'll continue having the warm line, which is the 415-920-5040 phone number, and that is manned by professionals who are also family members of children with disabilities, and they have a lot of information. They help support families in navigating special education and all of the resources and services that exist for our families. Again, my name is Joanna, and I was brought to this work 13 years ago because my oldest child, Yoleni, who is now 14, had a stroke in utero, and she was diagnosed with 10 different disabilities at birth, and we have been through this system. She has an IEP. She's always had an IEP since she was 3 years old. And so I've had to navigate special education for my own daughter. And I have become an expert in the world of special education, and I'm happy to share this information with families and professionals. So if you have any extra questions or you'd like some more information about our agency, you can reach us at the warm line or our email info@supportforfamilies.org. We've been serving families for over 40 years, and we're there to educate, empower, and connect families to the resources that they need. So we like to acknowledge the following resources. So this training was created through different fountains, and one of them was a Special Education Rights and Responsibilities Community Alliance for Special Education Case and Protection Advocacy, Inc. Manual that they created. You can find that online at the link that is on the screen, sir.disabilityrightscalifornia.org. It's a fantastic manual. In the world of special education, we call it, like our Bible, because it has every answer to every question that you have about special education. It's a great resource. So if you are looking for more information about special education that we don't cover in this basics of the IEP process, then definitely go to that link and get more information. We've also used the complete IEP guide, How to Advocate for Your Special Ed Child, by attorney Lawrence Siegel, who is amazing and who really supports our community as well. And finally, the California Department of Education Special Education Division, and you can find those documents online as well. So the purpose of today's clinic is to provide parents and professionals with an overview of the federal law that is called the Individuals with Disabilities Education Act, or IDEA for its acronyms, and how an individualized education program, or IEP, is developed. The objectives are to gain an understanding of the principles of IDEA, to get an understanding of the IEP process, and to provide resources and information relating to IDEA and the IEP process. So our agenda today, we're going to talk a little bit about special education and the law, because it's really important to understand the history of special education and why we have IEPs and IDEA. And then we're going to talk a little about what is IDEA and IEP. Then we're going to overview the 6 principles of IDEA, including IEPs. And it's really important to understand that so that you really understand the law and how to support families and how to advocate for your children if you are a parent yourself. And that includes FAPE assessments, IEPs, LRE, parent involvement, and procedural safeguards. And we'll go into the acronyms as well. And then we'll talk about the steps of the IEP process and timelines, including referral, assessment, IEP meeting, and placement in the least restrictive environment, and then the program implementation. Then we'll speak just briefly about additional rights, and then I'll open it up to questions. So special education law started a while back at this point. And to start us off, I just want to share some information about the history of it and how San Francisco in particular was pivotal in the disability rights movement. So Section 504 of the Rehabilitation Act was passed in 1973. This required that any entity receiving public assistance must ensure that individuals with disabilities are not discriminated against in any and all aspects of employment or denied access to goods or services that these federal fund recipients provided. Based on previous civil rights laws for women and minority, this came about, the Section 504. The issue was that this was vague and regulations were not passed to define non-discrimination. The disability community around the nation staged sit-ins for clear regulations that could be established. The one in San Francisco lasted about a whole month and eventually led to regulations being created and signed to set the bar for more disability legislation down the road. San Francisco was essentially the birthplace of the disability rights movement. This sets the stage for the ADA 10 years later, establishing that institutions must be accessible. And this brings us to 1975, when Congress enacted Education for All Handicapped Children, which was the name of it back then, or Public Law 94-142. In 1975, to support states and localities in protecting the rights of, meeting the individual needs of, and improving the results for children with disabilities and their families. Prior to this law, U.S. schools educated only 1 in 5 children with disabilities, and many states had laws excluding certain students, including children who were deaf, blind, emotionally disturbed, or had an intellectual disability. At this time and before, it was common for children with disabilities to be institutionalized or just kept at home without an education. So without this law, PL 94-142 in 1975, my daughter, who's visually impaired, who has intellectual disabilities, would have not been allowed to be in school. So this was really about access, opening doors for our students and making sure that there was a space for them to learn. In 1990, the amendments to and reauthorization of the 1975 EHA, or Education for All Handicapped Children Act, turned this law into what we know today as IDEA, or Individuals with Disabilities Education Act. This law ensures children with disabilities have access to a free, appropriate public education, or FAPE, and gives them access to special education and related services. It also changed the law to be about measurable goals. So in 1975, it was about opening doors and having access. And in 1990, it was about having measurable goals, right? So making sure that students were making progress in their education. In 2004, it changed to Individuals with Disabilities Education Improvement Act. And this was the reauthorization of IDEA by Congress with some significant changes to the law, which justified the slight name change to the law. This new iteration of the law aligned more with the 2001 No Child Left Behind Act, which aimed to ensure that all children have a fair, equal, and significant opportunity to obtain a high-quality education and reach, at a minimum, proficiency in challenging state academic achievement standards and state academic assessments. In practice, this required states to establish performance goals for students with disabilities that aligned with the goals of their peers without disabilities. The updates to this law also required schools to report on the progress of students with disabilities on standardized testing and had provisions aimed to improve graduation and dropout rates. The 2004 reauthorization also called for early intervening services for children not currently identified as needing special education, but who need additional academic and behavioral support to succeed in a general education environment, and greater accountability and improved educational outcomes. In 2015, they added Every Student Succeeds Act, and this was essentially an update to the No Child Left Behind Act. States are responsible for holding schools accountable And states can set their own goals for student achievement within the federal framework, with more goal flexibility than No Child Left Behind. So states adopt their own challenging academic standards. They also endorse UDL, or Universal Design for Learning, which aims to meet the needs of all students, including those with learning and thinking differences. It also required input from parents and families in the creation of state plans. So really important information. And my main intention in sharing all of this information is to frame that this was a long, long journey with a lot of people fighting for our students with disabilities and for all of the disabled community. And we really need to use these laws to empower us as advocates for our children, as professionals who work with students with disabilities, and make sure that we really look at the history of special education and the law, and recognize that there's so much effort that went into this. And I'm really glad it was, because I feel like my daughter has been able to succeed in school because she has an IEP and she has services provided to her. So moving along, we're going to talk about the IDEA and Individualized Education Program, or IEP, because this is an IEP clinic. So the Individuals with Disabilities Education Act, or IDEA, mandates special education services for children with certain disabilities who, because of this disability, need special education and related services. In the law, Congress states that disability is a natural part of the human experience and in no way diminishes the rights of individuals to participate in or contribute to society. Improving educational results for children with disabilities is an essential element of national policy, of ensuring equality of opportunity, of participation, independent living, and economic self-sufficiency for individuals with disabilities. It's really important to emphasize that that the most central law for IEPs is IDEA, which is the focus of today's meeting. And so I just wanted to let you guys understand the philosophy of IDEA. And keeping this framing in mind, we're going to dive into specific disability categories mentioned that are codified into special education law through IDEA. So IDEA 2004 defines a child with a disability as a child having one of the following eligibility categories. The reason you're going to keep seeing IDEA 2004 is because by law, IDEA is supposed to be reauthorized every 15 years, but the last time that it was reauthorized was in 2004. So we're still waiting on that 15-year reauthorization, unfortunately, and we're hoping that in this administration it will happen. But that's why you keep saying IDEA 2004. So in it, it describes these 13 following eligibility categories, and basically, in order to receive special education services, the local education agency, or LEA, must give a student an eligibility. Keep in mind, we have to use exact names to identify students, even if some of them, like emotional disturbance, may seem like outdated terms. In order for them to qualify, they have to classify under one of these 13 categories. To qualify for special education services, a student must be identified with one of these, as well as demonstrate the educational need for special education. Essentially, this means a student must be assessed and determined to have one of these 13 specific disabilities and must have a significant impact on their educational functioning and performance in the classroom. So the 13 categories are intellectual disability, hearing impairment, including deafness, speech or language impairments, visual impairments, including blindness, serious emotional disturbance, orthopedic impairments, autism, traumatic brain injury, other health impairments, specific learning disabilities, blindness, deafness, and multiple disabilities. And some students, like mine, who have a lot of these classifications, it really depends on what is going to give them the most services. So low incidence funding is extra funding that students who are in the hearing impairment, visual impairment, blindness, and deafness category would receive. So typically that's what my school goes for with my daughter. So they'll give her a VI as one of the classifications, and then other health impairments or multiple disabilities as another one, because under VI, she receives extra funding to provide more resources for what she needs in order to access her education. So special education refers to specifically designed instruction to meet the unique needs of a child with a disability. And so there are a lot of services that can be provided to a child with a disability if they qualify for special education. Some of these we're going to be talking about in these slides. These are just things that we have seen a lot, or things that are more rare. I didn't realize until just recently that getting vision therapy is harder than other resources or services that are provided. And so it's really important to understand like what kind of services there are in order for families to be able to advocate for them and for professionals to really understand how they can support a child's education. So some services may include audiological services, speech therapy, orientation and mobility services, instruction in the home or hospital, adapted physical education, vision services, specialized driver training instruction, counseling and guidance, psychological services other than assessment and development of the IEP, parent counseling and training, health and nursing services, social worker services, specifically designed vocational education and career development, recreation services, specialized services for low incidence disabilities, such as readers, transcribers, and vision and hearing services, speech and language services, and medical evaluations for diagnostic purposes. So this is just a sample list. And in the manual that I mentioned earlier, the one that was created by CASE and Protection and Advocacy, there are pages and pages and pages of services. Services can be either a modification, which changes the curriculum, or an accommodation to access the curriculum. So for example, some examples of modifications are allowing outlining instead of writing for an essay or major project, computerized spell check support, use of alternative books or materials on the topic being studied, word bank of choices for answers to test questions, film or video supplements in place of reading text, reworded questions in simpler language, projects instead of written reports, modified time demands, modified grades based on IEP. And then some examples of accommodations are large print textbooks, textbooks for at-home use, additional time for assignments, lockers with adapted locks, review of directions, having students restate information, and provision of notes or outlines. So one changes the way curriculum is done, and then one just helps the student access that curriculum. So it's fundamental that all the services meet your child's need and must be written into the IEP, because we're going to see in the next slides, the IEP is a legally binding contract. And so something that's important to note about modifications is if your child is receiving modified curriculum, that will impact their ability to receive a diploma. This equates to a certificate of completion at the end of their time in high school, and they have up until they're 22 to graduate. Even if your child is in elementary or middle school, this is important to keep in mind. If your student is making the switch from receiving modified work up until high school and immediately switching in 9th grade to be on the diploma track, this could be a significant and difficult change for many students. So the differences between accommodations and modifications is important to keep in mind when going into an IEP meeting and thinking about your child's needs, learning strengths, and vision for their life beyond school. This is a conversation to have early and often with your child's IEP. So this is something that can also change. When I first had my child go into school, I was like, she has to have a diploma. It's very important. Like, she needs to go to college. There's no other way. And honestly, she's going into high school now, and we're 100% on the certificate of completion track. It is therapeutically better for her. She academically is really strong in some things, but really struggles, and it really triggers behaviors because of the struggles academically. And I feel like for every family, it's very individualized, and it's something that we should really consider and consider all the options, because there are a lot of different options. And even if they don't graduate with a high school diploma, with a certificate of completion, they can still go to city college. They can go to any city college, basically. So there's one in San Francisco, Laney in Oakland, DBC, DBS. So any it's like city college they're allowed to go to. The four-year colleges, they would have to transfer, so they would go and do their time at a city college, and then they can transfer. But I want it to be clear that, everyone has a different path. Not all students are able to do the A through G requirements that are needed in California in order to graduate with a diploma. Some students, it's really challenging for them. Some students, it really triggers behavior and mental health, issues. And so you think of it completely individually for your child. And, things change, children change, and, different ideas of what is right for your child will change as well. So really just have this conversation as often as you can with the IEP team and make sure that the trajectory for your child is one that's appropriate for them. So IDEA core concepts. So the IEP requirements under Part B of the IDEA emphasize the importance of 3 core concepts. The first one is the involvement and progress of each child with a disability in the general curriculum, including addressing the unique needs that arise out of the child's disability. The second is the involvement of parents and students, together with regular and special education personnel, in making individual decisions to support each student's educational success. And the third is the preparation of students with disabilities for employment and other post-school outcomes. It's really important to monitor the involvement and progress of each child with a disability in the general curriculum. Also, the involvement of parents and students, I can't emphasize enough. It's really important that they become part of the team and that they understand that they're equal members of the team. And the third is just with beyond saying, I am launching this year a bunch of transition programs and a bunch of different transition supports in my agency for families, because as my child just turned 14 and she's heading towards 18 quickly, I'm realizing that transition is a really important piece, because IEPs protect our children under the law, but once they go to college, there are no IEPs. There are none of these protections under the law that IDEA has. And so it's really important to prepare them as much as possible so that they can be successful in their post-school outcomes, right? And so really figuring out, what does that mean for our child, vocational schools, college, jobs, and really having that talk with your IEP team and making sure that those transition programs are happening now. Once your child is 16, that is when it should. But honestly, at the 14-year-old age mark is really important to start, having these conversations with your student, having these conversations with your team. What are we thinking? What is it looking like? And really being prepared for what comes after high school, because unfortunately we lose the protection of IDEA after high school. And it's really important that we have something prepared for our students. So the changes that really were important under the last reauthorization of IDEA in 2004 were that parental written consent is required before an IEP team member can be excused. So this is really important because families have power in this. So in order for any member of the team to not attend an IEP, they have to ask permission of the parent. So this happens a lot in my personal daughter's IEP team, because she has a lot of members and we can never get 20 people at the same table. So a lot of times, almost every single IEP, they ask if someone can be permitted to be excused. They need to have my signature and my authorization for that to happen. And also, they need to provide a report, a written report that can be read and reviewed at the IEP meeting if they are not going to be there, to really understand where the goals are for that specific resource or for that specific service for your student. So not only can, they have to ask permission from the parents to be excused, they also have to leave something that states what is going on with the goals in that particular service. There are also new provisions that allow alternate means of meeting participation. So for example, conference calls if the parent and school agree. The agreement must be in writing too. So everything around special education has to be in writing. If it's not written down, we always say it doesn't exist. So everything should be written down. We encourage families and professionals to use email, because it has a date and time stamp. And there can't be, most of the times, unless it goes to your junk email, anything lost within those conversations. And so it's very important to have everything written down and to make sure that you have kind of proof, right, of anything that comes up. So if somebody states, we're going to provide this service for your child, and it was just verbally said, and there was no written after, a family saying, oh, well, in our IEP meeting, you said A, B, and C, then there is no proof that that happened, right? So it's really important that everything must be in writing. The changes to the law also included the shift of the due process burden of proof to on the parties seeking relief to prove that services did not happen or that IEP was not being followed. So this means that it's important to document instances in which you have concerns about the school providing your child their services outlined in the IEP. So it's just important that everything be written down, that everything be tracked, and that we make sure that everybody is in compliance. So now we're going to go into the 6 principles of IDEA. And the very first principle is free and appropriate public education, or FAPE. You're going to hear the acronym FAPE a lot. Special education has its own language. They use a lot of acronyms. A lot of times families do not understand what they are. Before I was manager, many years ago, I worked with families directly, and I went to a lot of IEP meetings, and a lot of times families had no idea what they were talking about because it's a completely separate language. So it's very important to understand what each acronym means in order to make sure that what they're talking about is appropriate and that families really understand. Because if they don't understand the acronyms, then they're missing out a piece of their rights, really, to understand and make informed choices. So what does FAPE mean? So FAPE means free. The F is for free. That means that all eligible students with disabilities will be educated at public expense. So there's no cost to the parent. They do however, have to pay some incidental fees. So for example, if general education students pay a fee to be on the soccer team, if a child with disabilities is also going to be on the soccer team, they're going to pay that fee. So for example, my daughter's in choir whenever they, and with general education students, and if they have to pay for tickets for their concerts, then we also have to pay for tickets. But otherwise, everything else is free. A is for appropriate, meaning that your child with a disability is entitled to an education that's appropriate for her. It has to be tailored and planned to meet the needs stated in the IEP. P is for public, referring to the public school system. Children with disabilities, whatever the nature or severity of their disabilities, have the right to be educated under public supervision. Many children will be educated in the public school, and in some cases, they might be educated in a private school. So the difference is if it is a private school, they are not obligated under IDEA to provide services in the same way a public school is. Public school is the one that has to follow IDEA to the T. And so they have to make sure that they are complying with everything under the law. And private schools do not. They have the right to say, okay, well, I don't think that this education is appropriate for the child. We cannot provide them extra services, and families will have to find those services on their own. But under public school system, they have to, because they are receiving federal funding. And so they have to follow the law to the T and make sure that they're providing all the resources and services that the child needs in order to access their education. And the last one is E, education, which must be provided to every eligible school-age child with a disability. If this describes your child, FAPE ensures that she'll receive a public education that includes the services outlined in the IEP, and that education should prepare that child for the future, further education, employment, and independent living. The second principle is assessment. So I'm going to talk about assessments because this is what drives everything in the IEP process. Assessments are so incredibly important to understand and really to review. So it's probably the most important part of the IEP process, as it helps the team understand the child's strengths and needs. As parents, we have to be super conscientious about the assessments during the IEP process. So when the school district starts to talk about assessments, we have to keep in mind that the assessment is the foundation of the IEP. School district is required to provide a comprehensive educational evaluation, which evaluates students in all areas of suspected disability. Even if they are not on the form, an assessment then is sent usually to the parents so that they are able to see what they're going to evaluate the children in. So even if an assessment isn't on the form, a family can ask for them and say that they want their child to be assessed in all these areas. So I recently got my child's assessment plan because she has her triannual evaluations. There were, 5 out of like 8 boxes checked, and I knew that she needed 2 of the other assessments. So I requested that. I had a conversation with her school and her IEP team, and they agreed. And so they're going to do all of the evaluations that I requested. So it's really important that families understand they can go back to the table and ask for more assessments than what are written in the plan. Initial assessments are done for eligibility purpose. So this determines if a child is going to have an IEP. These assessments must be done at least every 3 years, so they're commonly known as the triennials. But more often, if there has been a change in skills, improvement, or regression during times of transition, for example, the pandemic, or when a parent requests evaluation. So evaluations cannot be done more than once a year, but you don't have to wait the 3 years in order to get one done. Assessors must be trained and knowledgeable in their area of expertise. So for example, a physical therapist can't assess your child in the psychological area. Teachers cannot diagnose your child. It's really important even if a teacher has been working in the field for 30 years, that they do not diagnose a child. We're not getting diagnosis when we are making children, when we're evaluating children for special education. They're finding a classification and eligibility to see if they require extra services in order to access their education. Assessments must be conducted in the child's native language, and there must be multiple tools to reduce the bias. So they must use more than one testing tool to make a determination. And because of Larry P. versus Riles, which is a really important legal case, they cannot use IQ testing because of racial and cultural bias. So assessments cannot be discriminatory. So the relationship of service delivery. So it's really important, this timeline. And again, the reason we emphasize so much of this assessment is because this is what drives the entire process. So it's important to understand the role that assessments play in your child's IEP process. So the assessments, which are mandated to be done at least every 3 years, identify your child's specific areas of educational need and confirms the disability category. This educational need is then used to determine which services are appropriate to help your child reach their IEP goals and access the curriculum in the least restrictive environment. At the end of the day, services are determined by assessments. So services like speech, para, transportation, occupational therapy, physical therapy, etc. These services cannot be implemented without an assessment to identify the area of need. Assessment timelines can be frustrating. That is a valid feeling, but they ultimately determine the supports that your child will be able to receive. So they're very, very important to keep track of. When you receive an assessment plan, you can ask questions about it. It's a great time to be in consistent communication with your IEP team and ask what's going on, and request that the assessments be given to you before your IEP. So the reports that they write from the assessments, the families should have access to that before their IEPs so that they can make informed choices and know what they're talking about at the IEP meetings. So this is just an example of what an assessment plan would look like. So basically it says the local education agency, LEA or district, proposes to assess your child to determine his or her eligibility for special education services or continued eligibility and present levels of academic performance and functional achievement. Your child will be assessed in all areas of suspected disability as needed. To meet your child's individual education needs, this assessment will consist of an evaluation in only the areas checked by the LEA district. Tests and procedures conducted pursuant to the assessments may include, but are not limited to, classroom observations, rating scales, interviews, record reviews, one-on-one testing, or some other type of combination. And then it'll say what the evaluation area is, who the examiner is, and at the bottom, it says that the family consents or does not consent. And again, you can go back to the table and say, okay, well, I see that you've checked these things off, but I also need you to add health and motor development. And so you're able to request more evaluations if there is something that they missed. Oh, it also just very important key is that it's illegal to assess a child without the parent's signed consent. So if the case manager sends you an assessment, so if your case manager sends you an assessment plan to be signed, it's critical to get that back promptly to start the process and adhere with IEP timelines. So in order for assessments to be done in a timely fashion, it's really important that families sign and send back this assessment plan within 15 days of receiving it. It's a very important timeline to have in order for them to start the process. Okay, so the third principle is the Individualized Education Program, or IEP. So this stands for different things. So the first one is the process. So an IEP is not just a document. It's a process that entails progress monitoring, goal monitoring, communication, team meetings to discuss goals and progress, etc. It's also a meeting. So this happens at least annually, but can happen more than once a year if it's called. So if a family calls for an IEP meeting, the school must provide them a meeting within 30 days of that request. And third, it's a document. So it's a legally binding contract that's decided upon by the IEP team. So it's really important that families understand that once they sign it, the program is going to be implemented and they're moving forward. So something to note is you can sign with exceptions if you do not agree with all parts of the IEP, with a summary of the parts that you do not agree with. So the parts will not be implemented until consensus is reached. It's important to sign IEPs in a reasonable timeline. Nothing in the IEP can legally be enforced or implemented without a parent or guardian's signature. So it's super important that you sign with exceptions if you do not agree with everything, but you agree with something so that the process can begin. The fourth principle is the least restrictive environment, or LRE for the acronym. So this is an important principle of IDEA that for students to be included with their general peers to the maximum extent appropriate to their needs. This can look different for all students. The least restrictive setting is typically in the general education classroom with a general education teacher and consultation with a case manager or supplementary instruction and services in the gen ed classroom. So this often is in the form of co-teaching or the presence of a paraeducator, etc. The more restrictive settings can range from a special day class or an SCC to a residential school or homebound services, where there are more limited opportunities to engage with or interact with general education peers. So this is a continuum of placement, and this must permit a student to receive an education to the maximum extent appropriate with children who do not have a disability. The amount of time a child with a disability will spend with non-disabled peers and why not has to be in the IEP. And so there are percentages in the IEP document that state how much time a child is spending in with general education peers and without. LREs vary from student to student and they're based on individual needs. So LREs can change as a child grows and changes. For safety of time, I'm not going to go through the placement options, but we will share this slide. There are different kinds of placement options, and this isn't an exhaustive list, but these are some of the types of placements that are offered, and it is really dependent on the individual child, on what the team decides, and what makes the most sense to access their education. The fifth principle is parent participation. So parents under the law are considered to be equal members of the IEP team. So federal and state laws afford parents the right and responsibility to participate in the education of their child. This includes things like initiating a request for assessment, participating in the IEP meeting, agreeing and disagreeing with services offered. Remember that you can come back to the table and negotiate. You're a critical member of the team and you know your child. Getting to know the members of your IEP team and building relationships with them is a wonderful way to set up IEP meetings for success and receive meaningful progress, monitoring updates about your child. A key part of the IEP meetings is giving members of the team opportunities to share input and concerns. You will be asked to do this as a parent of a student with an IEP as well. Your input is critical to building a plan that is appropriate for the needs of your child. We know IEP meetings can be very overwhelming or challenging, but as a parent, you have the right to speak on behalf of your child because no one understands your child better than you. Central part of the IEP is the team component, and you are a very vital part of it. So typically IEP teams include a parent or family member, whoever has educational rights of the child, special education teacher, a general education teacher, principal or site manager, a school district representative, and service providers whose service is being addressed. So parents, that can include anyone that you want to invite. So maybe they're, you know, that you have a family member who knows your child really well and who wants to participate and has good input on your child. A care provider, when my child, her very first IEP, she had been being seen by Blind Babies Foundation at the time and Easter Seals for therapy. They came to speak on her behalf and you know, suggest different resources and services that could support her. I had a mentor at the time. I also invited her. So families really can invite anyone they want. Best practice is that you notify the school beforehand of who you're going to be inviting. And then also when your child gets older or it's appropriate for them, it's really important to include them because this is their life and these are their rights, right? And this is their education. So my child has never wanted to be physically present, but she's always, since she was around 8 years old, she's recorded videos of what she wants and doesn't want from school. That includes therapies, less therapies, more therapies, how she wants to be talked to, you know, what supports her in class in order to educate her, to access her education. So in any way that your child can participate in their own educational progress, it's very important to include them because it's really about them. It's really about their education. So the school district also must inform the family in writing of who will be attending the meeting, so you can prepare for that. So to prepare for the meeting is crucial for the family. You can share concerns, ask questions, make comments, provide input, and request changes when you disagree with the school IEP team member. It's okay to say, I'm not a professional, I'm not a teacher, I'm not a psychologist, can you explain that to me? So really getting to understand everything that they're saying. Like I said, the special education, we speak in a different language. It's very, very unique. It's very acronym based, and a lot of families don't understand. And so it's really important to ask for clarification when you don't understand something. And then last but not least, of the 6 principles is procedural safeguards. So this is really important because this emphasizes what signing with exceptions mean, right? And that any updated IEP services or goals cannot be implemented without a signature. So the reason that we have procedural safeguards is to make sure that families feel that they are being heard and that their child's rights are being, you know, implemented. So timelines will be covered on the next slide. And then so compliance complaints. So these are can be written locally or to the State Department. And basically it's when the school is out of compliance and you've asked for an IEP meeting and you've checked in and they're continuing not to comply with the IEP. Families can write up a compliance complaint and where they will do an investigation to see what is happening and why the services aren't being implemented, and then they will make a finding, and then either families, the service will begin right away, and they can provide compensatory services. So basically, if they said we offered occupational therapy 3 months ago, the student has yet to receive occupational therapy at school, and they find that the school is at fault and out of compliance, then compensatory services will begin. The student will begin immediately those occupational therapy sessions, and on top of it, they have to recompensate for the months that they miss. So it's really important for families to follow through with these. If you know you see that the school is not complying and you've reached out. So I really believe in collaboration. I really believe in creating a good, solid team, and you know, conversing with the team. And if you see that something's not happening or they're out of compliance, discuss that with your IEP team. And if they continue to say, yes, things are happening and we are complying, then you know, we recommend that you go through with the compliance complaint. And then resolution sessions. So this is the new addition under the law of IDEA 2004. So when a disagreement exists before proceeding with due process, the family and the district are required to hold a resolution session. So they come together and they discuss, and this must take place within 15 days of the identified disagreement. The purpose is to try to resolve the area of disagreement without attorneys present. Whatever is discussed in the resolution session may be used later in a court of law, which would be due process. And if the parent cannot, if the parties cannot resolve the issue in question, then due process would begin. And so the next part of procedural safeguards is due process. So this is used when disagreements exist, and there are two levels. So mediation and alternative dispute resolution. In San Francisco Unified School District, they use ADR a lot, and us as an agency, we recommend this highly to families because most of the times when families are either doing ADR or fair hearing, in fair hearings, a lot of times families lose those cases, and ADR, a very, very large percent in the 90s, are families, winning their ADR or resolving that that dispute in favor of them. So ADR is an alternate choice to a traditional mediation. ADR promotes the use of independent facilitators to help parties to mutually reach an agreement around the dispute that is happening. And IDR is set up slightly different for every school district. In San Francisco, they use the Bar Association of San Francisco as independent facilitators, and then Support for Families is the other neutral party that supports the families, and then the school district. And so they come together, they discuss, what the dispute is, and they try to come to an agreement. And then if that still doesn't work, then they can move on to fair hearing. So this is a much more formal version of mediation. So a hearing officer is assigned to hear out the case, and the hearing officer listens to both sides, calls witnesses, reviews reports, and comes up with a binding finding. So there are many different ways to resolve your disagreements with the school district, and we're lucky that we have these procedural safeguards that will protect our students and make sure that the school is complying with everything that's written in the IEP. Okay, so the steps of the IEP process and timelines. This is very important information to have. So the way this works is that a referral is done for special education. This referral can be done and requested by the parents or teachers, whoever works with the student and who is seeing that the student might need services in special education. So an assessment plan is created after 15 days after they receive the referral. So school has 15 days to develop an assessment plan and send it to the parent. Assessment plans sent to the parent or guardian must have their signature within 15 days. So it would be 15, 15, and then 60 calendar days to complete assessments, write reports, and hold initial IEP. So one scenario is a child will be found ineligible, so no services offered. However, the parents can choose to appeal findings. The way that they can choose to appeal findings is that they can request an IEE or independent educational evaluation, and then they can continue with the process. If a child is found eligible, then they will receive special education services and an IEP is developed. At the IEP meetings, they should implement the IEPs once the initial IEP is signed. Then they will have an annual review every single year. Typically, it's at the same time. Typically, it's around the child's birthday. And then they will have their triannual evaluations every 3 years. Again, families can request an evaluation be done before that. Sometimes families waive that at the 3 years. They see that there is no progress, the child's at the same place. They feel like they can give the child more time before they go through the evaluations. So there are different ways of doing it. Calendar days within those 60 days, something to be thoughtful of is that it includes weekends and all holidays lasting less than 5 days. So the only time that those 60 calendar days do not count towards the timelines are winter break, spring break, and summer break. That's really important because sometimes families are really frustrated and don't understand why the assessments aren't being done, but they started in, let's say, May or June or the beginning of June before school let out. It stops immediately once school is let out, and it begins immediately the day school resumes in session. So sometimes it's important to let families know that perhaps if you're going to be requesting this, try to do it earlier in the year, so in January, February, so that the school has enough time in order to complete all of this within the 60 calendar days. So these are just some additional rights that are covered under procedural safeguards. So an IEE, an independent educational assessment or evaluation. So this is if you just disagree with the results of the assessments conducted by the school district, you have the right to ask for and obtain an independent educational assessment for your child from a person qualified to conduct the assessment at public expense. The parent is entitled to only one independent educational evaluation at public expense each time that the public agency conducts an evaluation in which the parent disagrees. Access to educational records. So the school district must respond to the family's request for independent educational assessments and provide, if the school must provide access to records and copies within 5 days after the request has been made orally or in writing. So access to educational records would happen within 5 days of being requested. Suspensions. If a child exceeds 10 days in such a placement, an IEP team meeting must be held to determine whether the child's misconduct is caused by the disability. The IEP team meeting must take place immediately, if possible, or within 10 days of the school district's decision to take this type of disciplinary action. Stay put or pendency. So this rule is called stay put or pendency, keeping the child where they're at. If there is a disagreement, federal law requires that the child remain in his or her current educational placement throughout any legal review. So stay put is a unique aspect of IDEA, which requires that during the pendency of any proceedings conducted pursuant to this section, the child shall remain in their current educational placement. And then last but not least is prior written notice. So this is a written notice that schools must provide to the parents of a student with a disability within a reasonable time if they're going to reevaluate the student, determine whether the student is eligible for special education services, change the student's evaluation or educational placement or IEP, refuse the parent's request to evaluate their child or change their child's educational plan or IEP. The school district cannot make any changes without sending a prior written notice to the family. So anything that they do to change the way that a child's educational program looks, they have to let the parents know in writing and prior to changing those things. So that is the end of the presentation. I'm going to move through this and stop sharing, and then we can move on to questions. Thank you.
Thank you so much, Joanna. I'm going to go ahead and stop recording so that folks can ask questions. But before I do, can you share one more time if folks want to stay connected to the organization, future events that you're doing, and learn more about all of the work that you do? What's the best way for people to do that?
So they can go to our website, www.supportforfamilies.org. They can get on our mailing list to keep connected. We have a listserv as well. And so you can connect that way. And we are constantly updating our calendar and making sure that all the workshops are updated there. And we're also releasing a spring guide in a couple of weeks with all the workshops for the next 3 months.
Wonderful. Thank you for all the work that you do and for an amazing IEP clinic. Appreciate you. Okay, I'm going to